Chief Justice, Justices, good afternoon. We join the Attorney General of Canada to support the decision of the Ontario Court of Appeal that abolition of peremptory challenges should apply prospectively. We first submit that peremptory challenges is a constitutional right for all of the reasons stated by Mr. Durstein. But even if this court does not disagrees with this submission and says that at first glance the abolition of peremptory challenges are procedural in nature, we say that they affect a substantive right, and that is the right to a jury trials. And we say that we need to look at jury trials as a whole. We have to look at the new legislation's function and effects on existing rights, and that is the right of jury trials as it was prior to September 19 of 2019.
So the right to a jury has always been understood as a right to an impartial jury, and therefore a fair trial.
Yes.
So how does it affect the impartiality of a jury to remove a right which could be exercised by the Crown arbitrarily, that is, without reasons, and require them and your client to give a reason? How does that, in fact, actually in substance affect the partiality of a jury? Sorry.
It affects it in two ways we submit. It affects us both by removing the ability for the accused to participate in the selection of the jury, because the accused does not have a voice in the selection of the jury. And for hundreds of years, this was the process in which, yes.
That's what I'm wondering. How does that turn into a substantive right? Does it matter that it's been for centuries? At some point, did it just kind of morph into a substantive right? Do we look at the long-standing quality?
Because we submit that we have to look at jury trials as a whole. And part of what jury trials were is that right to have peremptory challenges. And this right was that this is what existed prior to September 19, and this is what an accused was entitled to have, which included peremptory challenges. And we also say that
it's substantive. If we're looking at juries as a whole, it doesn't allow us to distinguish between aspects of the right to a trial by jury that are procedural and aspects that are substantive in nature, unless what your submission is you can't touch anything. They're all substantive.
We submit that really the removal of peremptory challenges affects the statutory right in two ways, by which of the appearance of fairness to the accused, to have a fair trial, as well as the composition of the jury trial. And this is exactly what the Court of Appeal found, that by removing the peremptory challenges, you negate the right of the accused to participate in the selection of the jury and to have a right in the composition of the jury. And given the fact that you negate that right, this is a substantial impact on that statutory right to a jury trial, and as a result, it cannot apply retrospectively.
So when would it be deemed to be procedural?
Pardon me?
When would it be deemed to be procedural? Any changes to the jury selection process?
If
it's not always substantive, like you seem to say, when it would be procedural?
If it would be simply, if it did not take away any rights of the accused. For example, if we look at the challenge for cause provision, the challenge for cause are still in place. The peremptory challenges, we are completely removing a portion. We are taking away, we are not changing the procedure of the peremptory challenges and reducing the number of peremptory challenges. We are taking away that process entirely. And as a result, we are taking away that right of the accused.
So the number of peremptory challenges, if you change the number, that would be procedural, but if you remove the whole peremptory challenges, that would be substantial. Is that?
Well, if you remove the entirety of the peremptory challenges, the accused no longer has a say in the composition of his jury. He no longer has that procedure that has been in place. And we say that that is a substantial change in his right to a jury trial.
Well, just very quickly, this is all very interesting and debatable, but your example of the challenge for cause, now we have trial judges doing it as opposed to rotating jurors or static jurors. So if I'm an accused, I say, you took away my right to have members of the community make this call, as opposed to a trial judge who is a white male and doesn't understand this. So there you go. Right away, you've got a substantive right there. So I'm just trying to take up your example and say, along the lines of the Chief Justice, I think if you change any right in this context on your thesis, the accused could stand up and say, you can't do that. That's substantive.
But in our view, it's not simply a change of the procedure, it's a removal entirely of that process. And that's also supported by the Attorney General of Canada. If you take away that entire portion of the process in the jury trial, the accused no longer has a say in the jury selection process. And we say that that affects substantially.
It's been limited, I'll grant you that. But you still have a right to stand up in front of the judge and say, despite the fact that the challenge for cause is unsuccessful, I want you to stand aside this juror because X, Y, and Z.
But it again goes back to saying that it's very difficult to, for an accused to go and verbalize all of his feelings. And it goes back to Mr. Durstein's example of a woman who's...
Better we should let them engage in quiet discriminatory conduct.
I think we got your point. Thank you very much. We'll go back to Zoom now with